Good afternoon. Good afternoon. Good afternoon. Good afternoon. This is Tracy B from the Divorce Solutionist. I am back for Thick of It Thursday, where I discuss some family law related topic where I go into detail about a real case, not my case. It could be anyone. I can get it from anywhere, a group, um, a page, a magazine, a newsletter. I'll just get a topic or a few topics, and depending on how popular I think it is, how intriguing, interesting, complicated it can be, I will discuss it. So, I mentioned a couple of weeks ago that I decided to do a pro se trial prep workshop, which is in the works. I don't have a date for it yet because I'm really, really dragging my feet with that because I have so many other things that I'm trying to put together. And but it's helping me because it's helping me narrow down what's more important from a pro se litigant's point of view. Because me, I'm a little biased. Even though I was a pro se litigant, it's not the same because of my background. So I'm trying to get a real sense of what's important to a pro se litigant and to put it together where then you're not overwhelmed or it's not so complicated or too much legalese is being used. So I'm taking my time because I want it to be something that anybody can relate to and understand and sort of, get the benefit of it. So that's that. I am also still working on a few ebooks. The first, I'm going to come up with a volume of 5 to start with, and I'm working on the first one, which should have been done already, but life gets a hold of me, and I just get caught up in so many other things. But that ebook, the first volume of the ebook, which is called "Divorce is Chess," that is one of my signature program topics or titles. Divorce is Chess. So I'm going to do volume 1 in the series of Divorce is Chess. And that should definitely be done by the end of May. Yes. Because I'm working on it. I actually have, content. I actually started working, putting it together, but that's what happens when you try to multitask. I'm trying to wear too many hats. But anyway, that is coming. But because of the pro se trial prep workshop that I'm putting together, I decided to do a few topics related to trial and trial preparation for pro se litigants, for anybody going through a family court hearing / trial, either now or one coming up. So I talked about I think I talked about audio and video and things like that being used in family court um, hearings and trials. I think I talked about that last week or something. And this week, I wanted to spend a little bit more time talking about hearsay. Now, hearsay is something that it's a legal term, but because of the explosion of all these resources on the internet and beyond, most people who are going through any sort of litigation, it doesn't have to be family law only, any sort of litigation, whether it's pro se or they're being represented by someone, um, has gotten familiar with the term hearsay. Um, Even if you watch TV, you can watch Law and Order or the reruns because it's in syndication now, or any show that does trials. Even some of the real crime drama TV shows, you'll see someone in the midst of the trial or pre-trial discuss hearsay, and so it's not as esoteric as it used to be. Now people are starting to understand, even lay people are starting to understand exactly what it is. The thing is, even understanding, there's still so many other things that go into understanding how hearsay plays into trial. I'm going to focus mainly on family court trials because, as I mentioned before, family court is a very, very unique venue in and of itself. It's not like criminal court. It's not like civil court. It's not like any other court, because family court is it's it's a myriad of courts or tribunals or venues all in one, because in family court issues, there's a lot of emotional issues, um, social economic issues. So all of those things have to be addressed because they all intertwined into the specific issue by which the parties are in family court. So if it's custody, child support, visitation, whatever it is, somewhere in there are other issues that have to be brought up and have to be addressed to even get to the issue for which the parties are in court. Sorry, I'm really dramatic with my hands today. Excuse me for that. So hearsay is something that it's a really interesting tool. And I call it a tool because you can use it once you get a little familiar with how to use it and understand what it is. You can use it to your benefit or not. You know what I'm saying? What I mean by that is you could, if you know something is hearsay and it's the opposing party and they're trying to introduce it into your hearing or your trial, um, you could not object because you want that hearsay to be admitted. Because it's not something typically that the court would raise. It's something that the opposing party has to object to for it to be considered inadmissible. And that depends on where you are. When I speak, I'm speaking generically, but every jurisdiction is different. Every jurisdiction operates differently. So it's always key to know, how your jurisdiction, get a feel for it. I'm going to digress for a minute, but if you have a trial or a hearing coming up, um, whether you're pro se or not, I always advise people to go in to your particular judge who's going to hear your case and try to get a feel for how they operate in the courtroom, how they move around, how they rule, the decorum, how they speak, any biases or prejudices they have. You always want to know that ahead of time. So even with, hearsay or any other technical issue that may come up in trial, you may want to take a trip either a week, 2 weeks, a month prior to your actual hearing slash trial to get an idea of what you're going to be up against. And that is across the board. That doesn't matter if you're pro se, if you're represented, if you're in between, it doesn't matter. You should definitely get a feel for the person that's going to be ruling in your case, specifically, especially, emphatically, if your case is going to go to trial. If you have a custody case and you know it's going to go to trial, it behooves you to go in and sit in and get a feel for how your particular court, operates. If you can go in and sit in on another trial or another hearing, that's ideal. That's the best case scenario. But sometimes, depending on where you are, the court isn't open, especially now because things are opening up. So it's not as restrictive as it was, this time last year because courts were doing everything virtually. But now, if the courts are open and they allow you in to watch a hearing or something, it's advisable. Um, if the courts aren't open and everything is still being done virtually, then you can ask around. There's a plethora, I mean, a gazillion groups on Facebook now. I know because I'm in a billion of the gazillion groups that are custody, child support, family law related. And in there, if you go in there and become an active member, you will almost guarantee to find someone who's had a case before your particular judge. Don't wait until the day before and try to look for them. Try as soon as much in advance as you can, and talk to them and ask them, because I just think it's essential for you to know what you're walking into. Every particular judge does not operate the same way. They can even be in the same jurisdiction. They're still not going to operate the same way. Some judges are going to object to a hearsay. Some judges are going to sustain a hearsay objection, while another one may, overrule it. And it could be the same exact hearsay problem. but no two judges are alike. And there's no right or wrong. That's just how they see it. So it behooves you to, as much in advance as you can, to try to have a discussion, a brief discussion, if it's through Facebook, with someone who has, been before your judge, or even in that venue that you're in. Trust me, it's valuable information. And I'm saying that only because I just realized that a lot of courts are still virtual. I think the courts here are starting to open up either next week or the first week in June, is what I heard. So, but my guess is that they're still going to be quite restrictive with allowing people to just come in and sit in on cases or whatever. But the other alternative is, if you show up early enough, if your courts are open, if you show up early enough to your own case, you might catch the judge in another case before you, and they may allow you to sit there because they'll know that you're there for a legitimate reason, as opposed to just being an observer. So anyway, that's my little tip of the day. So hearsay. Excuse me. What is hearsay? Hearsay is usually defined as a statement made out of court that's trying to be used in court to assert the truth for which you're using it. Okay, let me say that again. It's an out of court statement that's admitted for the truth of the matter that's being asserted. So let me just make a distinction. So I'm going to give you two distinctive examples. So in family court, as you know, not just me, but most family law practitioners tell their clients, document, document, document. Gather evidence, pay attention, prepare, explore, discover, keep your eyes open, your ears alert, because anything and everything could be used. Now this is me talking, whether we use it in court for hearing or trial, or we use it in court for negotiation settlements, we use it in mediation, or we use it just amongst ourselves to create a strategy, because that's me, the strategy queen. The reality is, pay attention to everything. A lot of people, and I'm not trying to be biased in any sense right now, but I'm going to tell you from my experience, a lot of stay-at-home moms have the tendency, the propensity to not know where their husband bank at, or which credit cards they have, or who holds the mortgage, or blah blah blah. So once the divorce action commences or custody starts, now it's imperative that they become privy to this information, because they need to know. They need to know what the assets are. They need to know what the liabilities are. They need to know the sources of income. If they're seeking alimony and child support, they need to know all that. So now they need to gather bank statements, telephone records, mortgage statements, credit card statements, bills, blah, 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 et cetera, et cetera. So in that, some of those things may be considered hearsay, some may not. So I'm going to give you two distinctive examples. So an allegation in a particular divorce proceeding is that mom should get full custody because the 12-year-old child, I'm just, coming up with something off the cuff. The 12-year-old child is not doing well in school because, she told the counselor it's because her dad yells and screams and is angry all the time, and it creates anxiety for her, so she doesn't sleep at night. And when she gets to school, she doesn't perform properly. So same scenario. Now I'm going to show you the difference in what's hearsay and what's not. So mom wants to now use the records from the discussion the 12-year-old had with her guidance counselor to prove to the court that dad is unfit to have custody because he yells, he screams at his daughter, and it causes her to have anxiety. Okay? As opposed to she wants to introduce the records to show that, let me think of a really good example, to show that the child has anxiety. Okay, that's different. I don't know if you noticed the difference. Just to show the child has anxiety, has nothing to do with custody, nothing to do with anything. She just wants to prove to the court that the child has anxiety, period. Do you see the difference? The first one is she's alleging dad shouldn't have custody because he's verbally abusive and mentally draining on the child. And so she wants to use those records with the guidance counselor to prove her position. She wants to prove that it's true because the daughter told the guidance counselor. In the second scenario, she doesn't want to prove that the dad really done this. She just wants to prove that the daughter does have anxiety. You see the difference? It's the same. She's still seeking the same thing. It's custody. She just wants to prove a point. Yes, my daughter has anxiety. Doesn't have anything to do with custody. I just want the court to know my daughter has anxiety. You see the difference? That's the difference. That's a huge difference. And that's an argument that someone opposing or objecting to someone who's rebutting an objection to their trying to admit that into evidence is going to say, well, I'm not trying to allege that I'm not using it to allege truth of the matter that's being asserted. I just want to admit the records to show that my daughter has anxiety, just so that the court is aware of the fact that my daughter has anxiety, which has nothing to do with nothing, but I just want the court to know that. And I'm simplifying this so that you'll understand the difference, the distinction. But so so let me break it down. So a statement can be anything someone says out loud or in a statement. But a statement can be written, it could be typed, it could be a letter, it could be an email, it could be a text message, it could be a voicemail, it could be any kind of record. Those are statements. Those are statements. Doesn't matter the form. Any of those forms, it's still a statement. Okay. And out of court means it's not a part of a hearing. It's not part of a former court proceeding where there was no hearing. It was just a court appearance or conference. Anything outside of that. One thing that's really, and I should have researched this issue because I don't remember. It's been so long since I've practiced. One thing I can't remember is if statements, sometimes when you go to court for a conference, that same day, the judge sends you to a mediation room. The judge will send you from court, from the conference with the judge, he'll send the parties to a mediation room. There'll be mediators like on the premises. And I'm not quite remembering if those are considered out of court statements, if statements made in a meeting. I think what's happening now, if I'm not mistaken, is that the parties have to sign an agreement. And I think, I wish I would have researched. I think it depends on what the agreement says. I'll look that up. I'm going to research that and actually comment to this post to follow up as a follow up. But admit it. Admit it means given, presented, or entered into a hearing or trial. So in most cases, it is evidence or testimony that a party or a party's witness is giving to the court for the judge to consider it to make a decision about the case. And that's where the distinction comes in at. Where the former is she wants the court to use the guidance records to make a decision about custody, where the latter is she didn't want the court to use those records to make a decision about custody. She just wanted the court to know that the child had anxiety. Okay. Same thing about the truth of the matter asserted. The evidence or the testimony is presented to the court to prove the fact contained in the statement. And again, I simplified my two scenarios because some people will argue that, well, she's still using the guidance records to prove that the child has anxiety. But that's a tangential issue in court. I mean, the opposing party may not dispute that because the party presenting that is not trying to persuade the court to make a decision just because the child has anxiety. They may just want the court to know that the child has anxiety, to not bring the court, to not, I don't know, think of something. But anyway, I don't want to get too complicated. Hearsay, explaining hearsay can be very, very, it's a tool. That's why I call it a tool, because depending on where you're sitting, you may decide it is hearsay or it's not. And you could be in the same exact scenario months later and have the same exact, be in the same exact position with the same hearsay and flip, and there's no right or wrong. It's just a matter of using it properly and being creative and strategic about how to use it. If you are pro se and you have hearsay or a lot of hearsay, records you want to introduce, statements, video, audio, text messages, emails, all that stuff, I suggest you work with someone to help you understand, to get a better grasp on. And I say that because in most of the cases, most of my clients, a lot of what they're presenting to the court is based on a lot of those records. They have tons and tons and tons of evidence that they've gathered, of documents, of audio, of video, of Facebook posts, of so much stuff. You need to have it organized. You need to have an idea of how to organize it so that you can categorize it, so that you'll have it. If you're going to go to trial pro se, you won't waste your time. And I get this a lot. Well, someone will come to me. Someone said to me, I think last week, oh, I had so much evidence, but I didn't even get it in. Like the judge wouldn't allow it in, any of it in, or a lot of it in because of this, because of that. And I'm like, that's why you should organize it, and you can't do that by yourself. If you're going to go, and I don't think that you absolutely need a lawyer to represent you in certain cases. I don't. And people will beg to differ with me. That's fine. I'm not arguing with anybody. I don't argue with people who take a position. I just respect their position and ask them to respect mine. But I don't necessarily believe that you should spend $20,000 to argue custody case when you're seeking joint custody in a joint custody state. That's a waste. It's a joint custody state. If you want to try it, fine, but don't spend $20,000 in having a joint custody trial in a joint custody state. It's gonna be awarded anyway, so why bother? But if you are, the thing is prepare, at least prepare for it. Prepare as much as you can. And one way to prepare is to work with someone to help you organize your evidence. You have to, even if you don't know the actual rules of how a court proceeding operates, how a trial goes, the order, the terminology, you need to work with someone to help you put all of your evidence in order. A lot of lawyers work with trial notebooks, and they do that for a reason. They do it you don't have to have a trial notebook per se, but you should definitely have all of your things organized so that, and yes, some judges are more lenient for pro se litigants when it comes to, evidence, even the rules of evidence and trial procedure, but some of them aren't. Some of them are even more punitive on pro se litigants because they think, how dare you, waste their time. And to them, some of them, it is a waste of time because it takes a little longer, because a lot of times they have to explain things to you. How dare you waste their time coming in there pro se on a trial or a hearing? And I'm going to use those terms interchangeably. But so anyway, I digress for a second. But I just wanted to express how important that is. So there's questions. There's questions to ask. Are the statements trying to be used in evidence? Are you attempting to use them in evidence? In testimony, I'm sorry. So if someone is testifying and they're trying to bring up an issue, a statement or something, and it's hearsay, or it sounds like hearsay, the other party, the adversary, the opposing party, is going to object, right? And so the person who is who called that witness may have an explanation as to why it's not actual hearsay. And that's where the exceptions come in at. There's a ton of exceptions for hearsay. I'm going to go through, let me see, there's 1, 2, 3, 4, 5, 6. There's six there's six major exceptions, widely used exceptions. There's others. It depends on the state you're in, because each state has their own list of hearsay rules. One of the most common ones, though, in family court is business records. That's a typical hearsay exception that's widely used, and that will be that will come up often, and that's because of the nature of evidence that the litigants bring in there. So, business records are records that's kept by a business, government, or organization in a regular course of business. If that's what it is, then they may qualify for the hearsay exception. So this can include hospital records, rent sheets, utility bills, report cards, school attendance records, things like that. These may all qualify for the exception, but they have to be certified. You have to get them certified. So what happens is, if you're going to use them, what you typically have to do is you have to subpoena them, get the judge to sign off on a subpoena, or a lawyer, because you can't do your subpoena yourself, and send it directly to the. I'm not. Go ahead. Sorry about that. Um, Sorry about that. He knows better. I don't know why he did that, my son. Um, and then it has to be certified, and that will prove or negate any argument or allegation that the record is not authentic. Okay. Um, and a lot of times, yeah, I'm thinking, because I'm trying to think of I was trying to think of a hypothetical situation where, like, most of the documents or the evidence was hearsay. Okay. Especially in custody battles. In custody battles, there's usually medical records, therapy records, school records, attendance records. I'm trying to think of what else. I mean, and that's just for the child. There can be, hospital records for the adults to prove that, or disprove that they have illnesses. Um, uh, so many other things. Jail records, police reports, if there's DV allegations, there's so many. Now, you're not going to get them all in if you have tons of them, because some of them are just not going to meet the exception, because, and I'm not being pessimistic, I know better. But that is a very common exception to hearsay in family court. And a lot of them, yes, you can get around them. You have to follow the rules for your particular jurisdiction, though, around getting around them or getting them admitted, meeting the qualification of criteria to get them admitted. Another one that falls under that is public records, which is, something like birth records, marriage certificates, things, paternity records, things like that. That's also a very common hearsay exception. So, as I mentioned before, hearsay is a tool, and I'm going to end in a few minutes, because and then next week I'll pick up and discuss some other exceptions and get more into those. Is a tool. So just because you might want to get hearsay in, and it may actually be hearsay. It may fall under hearsay. But again, if your adversary or your opposing party does not object to it being admitted, then it can very well, make it into, being admitted into evidence, despite the fact that it is hearsay, because it's not something the court is going to do sua sponte. Well, sometimes they will. It depends on how blatant it is. But if it's questionable and the other party doesn't object, um, then the judge may, say, no objection raised, so the court is not going to raise it for you, and I've heard judges say that. And I've heard judges say that a lot, especially again in family court. And I don't want to keep stressing that family court is informal or try to imply that it's informal. But we all know, practitioners know, someone actually, a lawyer in another group that I'm in, brought it up the other day. She had a criminal law background, so she was used to criminal trials, and she came in and was like, "Oh my God, I just had my first trial in family court, and I can't believe how many rules the other lawyer was breaking, like as far as evidence is concerned." And all the other family lawyers chimed in and was like, "Yeah, that's normal." She's like, "Well, those rules are really, really enforced in criminal court." And all of us were like, "Yeah, but there's a difference. In a family law tribunal is very different than being in criminal court. Criminal court, first of all, there's more at stake. Appeals are like inevitable. In family court, not so much, and judges know that. They usually they have the final say. They know the chances of litigants actually appealing a family court decision, custody, divorce, or whatever, is very, very slim because it's so costly to do that, which is one of the reasons why some of them will allow, what I said was, maybe hearsay. They may just not even, object or sua sponte. They may not bring that issue up themselves. So anyway, I hope this was helpful. I hope you understood what I said. I know I was kind of all over the place, but I'm hoping you got a sense, at least a basic understanding. Again, I'm going to resume hearsay for next week, and I am going to find out about the mediation question, whether or not things said in mediation is considered out of court or whether uh, it's not, because only in instances where the mediation happens, like literally right outside of the courtroom. So anyway, again, I'm Tracy B from the Divorce Solutionist. I am a divorce strategist slash coach slash consultant. I do not try cases. I do not represent people on cases. I help them prepare cases, navigate their case. I do unbundled services. I prepare documents. I review documents. I file documents for people. I do research. I screen attorneys for you. I look up judges. I do a lot of other things. But the Divorce Solutionist is my baby. I developed and created to create solutions for those who are going through, and it's not just divorces, it's custody and divorces, mainly. Some other stuff, some paternity, some child support, but mainly divorce and custody. I provide solutions for wherever you are in your case, whether you have an attorney or not. My services are for those who are sick of being beat down by the family court system, who are sick of spending money, who don't believe they should spend $20,000 and not get the best representation, or whatever their reason. So I do pro se coaching and consulting. I do whether you're represented, I do coaching too. I do individual coaching, group coaching, membership coaching, um, all those things. So my website is www.thedivorcesolutionist.com. My email is divorcecoachesq@gmail. My Facebook groups are the Divorce Glow Up and Pro Se Divorce and Custody. My Instagram handle is the Divorce Solutionist. My LinkedIn is the Divorce Solutionist. My Twitter is the Divorce Solutionist. I think that's all I have. But anyway, thank you for joining me today. I look forward to working with or meeting with each and every one of you. But until then,